Straight ahead on Law&Crime Daily. The Gabby Petito family versus the Brian Laundrie family.
They made that very callous, that very terrible statement, giving hope to Joe and Nicole that perhaps Gabby was still alive, with full knowledge that she was not.
Could the civil suit be headed for trial? And
knowing the individual's background, it has to have something to do with why we're all here. So you have to take that into consideration, I guess.
A date is set and jury selection enters its final stretch for the penalty phase of the Parkland school shooter. Plus,
the manner of the direction, was it in a front to back downward motion?
I would presume it's front to back.
Conflicting testimony on how a beloved pet was shot as Candy the dog's civil trial is back in session. And later, what it would take for Amber Heard to appeal.
When that is entered, meaning stamp filed in her court, that's when the 30 days start ticking.
Our legal analysts break down the appeal process. Law&Crime Daily covering court cases from coast to coast. Welcome everyone to Law&Crime Daily. I'm your host, Brian Buckmire. Nearly 1 year after Gabby Petito and Brian Laundrie took an ill-fated road trip across the country, their parents face off in a Florida courtroom. Gabby Petito made national headlines last fall after she was reported missing in early September. Her family told officials she had been on a cross-country road trip with her fiancé, Brian Laundrie. Petito's body was later found in Grand Teton National Park. Her cause of death was ruled to be strangulation. After a weeks-long manhunt, Laundrie's remains were discovered in a Florida reserve. Authorities determined he died by suicide. Along with his remains, investigators found a written confession where Laundrie admitted to killing Petito. Months later, Petito's parents filed a civil suit against Chris and Roberta Laundrie, arguing Brian Laundrie told his parents about Petito's murder in late August of last year, and that they later helped conceal his location before he went missing. On Wednesday, the Petito family appeared in a Florida courtroom for a motion hearing. The Laundries did not appear, but were represented by an attorney who argued the Laundries had a right not to speak up under the Fifth Amendment. The Petito family attorney then countered, saying the Laundries' actions gave the Petitos false hope.
Conduct that amounts to remaining silent and maintaining privacy is not intentional infliction of emotional distress. And there are no cases where such conduct was found to be intentional infliction of emotional distress. Rather, plaintiffs argue that the Laundries had an obligation, a duty to speak. The law imposes no such obligation to speak.
They knew, starting on August 28th of 2021, that Gabby was dead. They knew where Gabby's body was. They knew that the Petito family was desperately searching for information, but they did things affirmatively. They didn't just remain silent. Brian Laundrie came home in Gabby Petito's van by himself to his family's home. That family, knowing that Gabby was dead, knowing their son had murdered her, knowing where the body was, and in particular, knowing that Joseph Petito and Nicole Schmidt were desperate to learn where their daughter was located, they went on vacation. They assumed and continued their normal life as though nothing had happened, while this family was suffering, wanting to know what where their daughter was.
The judge said he will make a ruling in the next 2 weeks as to whether the case goes to trial. Right now, it's set to be tried in August of next year. Joining us today is former SWAT and detective Lisa Lockwood and co-host Terri Austin. Lisa, if the Petito family ultimately wins the lawsuit, does it mean that going forward, people will have an affirmative duty to report any information they have about a crime?
I think this will set a new precedent if we do get a win in this case. And that precedent would be civilly that people are liable, will be held liable for compensatory damages if they are not forthcoming with information regarding a crime. In this particular case, the assumption is they knew what Brian did, they knew where Gabby's body was, and they completely stonewalled her family. And this was a close relationship prior to that. So civilly, it may hold up because all of it appears from the outside to be an intentional infliction of distress, emotional distress on this family, because they had information that could have helped find their daughter a lot sooner, and they failed to do so.
Well, here's hoping this goes to trial so we can unearth a lot of these facts. Terry, the attorneys on both sides made strong arguments. Which side had the better ones, though?
You know what, Brian? They both made very strong arguments. The Petitos are trying to show that there was intentional infliction of emotional distress, as Lisa mentioned. And in order to show that, they're going to have to show that the Laundrie family, they acted intentionally and recklessly, that it was extreme and it was outrageous, and that they caused that severe emotional distress. They argued a lot about what is outrageous behavior. And the judge asked some very difficult questions. He asked both attorneys information about the case. So we'll see what happens, but I do hope it goes to trial, and I do think the judge is going to allow it to get to that point.
Yeah, I want to know how, when, do they know exactly that Gabby Petito was dead, and what do they do? These are some major facts and information, of course, we'll bring to you if and when this case goes to trial. Switching now to celebrity legal news. For the first time since a verdict is handed down, we're hearing from the spokesperson of comedian Bill Cosby. Earlier this week, Cosby was found liable in a decades-old sexual assault case brought by now 64-year-old Judy Huff. She claims the comedian sexually assaulted her at the Playboy Mansion in the 1970s when she was just 16 years old. It's the first time the civil case has made it to trial since Cosby was released a year ago after his criminal conviction for a sexual assault alleged by a different woman was overturned. Late Tuesday afternoon, jurors awarded Huff $500,000 in damages, but no punitive damages were awarded. While Cosby was not present for the trial or the verdict, his spokesperson says the famed actor viewed the verdict as a win.
The $500,000 was a huge victory for us. And the reason why I say that is because they could have given her unlimited damages and punitive damages, and they did not, which told us that, yes, they wanted to punish Mr. Cosby, the jurors, and we found out from juror number 2 and juror number 3 who spoke with Mr. Cosby that many of the jurors came in with a bias against him. Many of the jurors came in saying, we have daughters, and we just think he should be punished. But they didn't feel that Judith Huff really reached her burden.
Still ahead on Law&Crime Daily, the Candy the Dog civil trial resumes after several delays due to COVID. But first, we head to Florida, where opening statements will soon be presented in the penalty phase of the Parkland school shooter. After nearly 3 months of jury selection and several setbacks, a new date is scheduled for the penalty phase trial for the Parkland school shooter. Back in October, he pled guilty to killing 17 people in the February 2018 mass shooting at Marjorie Stoneman Douglas High School in Parkland, Florida. The incident sparked nationwide conversations about gun control measures and mental health. A jury made up of 12 people will decide whether the 23-year-old should spend the rest of his life in prison or be put to death. Jurors will consider whether several aggravating factors, including his planning and cruelty, outweigh his history of mental and emotional problems. On Wednesday, Judge Elizabeth Schreier signed an order to begin opening statements 2.5 weeks later than planned, as attorneys work to narrow down the jury. Dozens of potential jurors enter the final round of questioning this week. Attorneys asked potential jurors about considering the defendant's background, if they are chosen.
After looking at these 17 sets of crime scene and autopsy photos, right? For many people, and rightfully so, the background history of the person that did that doesn't matter to them anymore. My fear is, once you've seen those photos, that you're really not going to consider the guilty murderer's background in your punishment decision. Is that a valid fear for me to have?
I can understand your fear, but knowing the individual's background, it has to have something to do with why we're all here. So you have to take that into consideration, I guess. In other words, the events that took place is why we're here. And the individual that did that, obviously, we have to learn all the information, and I'm sure his background has something to do with it. We would have to take all the evidence in and weigh it.
Opening statements are now scheduled to begin July 6th. Testimony is expected to last for 4 months. Terri, this mass shooting has sparked discussion about gun control. Do you think this case will actually change gun control legislation?
You know, Brian, unfortunately, I don't think there are going to be any changes at all. We've already seen on the federal level that the bill before the House and the Senate, it's already watered down. There are no bans on assault weapons, no bans on bump stocks, no bans on high-capacity magazines. And we already saw today the U.S. Supreme Court struck down New York's gun law, which says you can't carry a concealed weapon, that's a violation of the Second Amendment. And we've had that law in place for years. So I don't think these mass shootings are going to change anything at all as far as the legislation is concerned on the state or federal level.
Yeah. Now, Lisa, with these mass shootings and the legislation and this national discussion, do you think that these string of shootings will affect jury selection process or even the death penalty phase for the shooter here?
Well, I don't. We've had the death penalty for decades, and there has never been a deterrent or a lower crime statistic based on having death penalties in various states, especially when somebody has mental or psychological issues. It's not even a thought. They will go ahead and do what they are planning to do without thinking about the consequences. So I don't see that as a deterrent going forward, but death penalty, I've had issue going back and forth. I'm glad I'm not sitting on that jury right now.
I would agree with you on, I always agree with you, Lisa, but definitely on that point as well. Well, coming up on Law and Crime Daily, Johnny Depp and Amber Heard's teams are due back in court. Plus, closing arguments inch closer in the Candy the Dog civil trial. Welcome back. A veterinarian takes a stand in the so-called Candy the Dog civil trial just before the defense rested in a Florida courtroom. The case surrounds an incident in 2016 when Zach Dieterle shot Candy, Rodney Jacobson's terrier mix. Dieterle claimed the dog was in an attack stance when he shot her. Local officials say Dieterle was not charged because he had a right to carry the weapon in that he had a permit, and that he was within his rights to use deadly force because he feared for his life. Jacobson says Candy had no history of aggression. This week, the case was forced to take a several-day break due to multiple jurors testing positive for COVID-19. The trial resumed Thursday with the final witnesses testifying for the defense, including a veterinarian who told jurors a different story from a previous witness. Last week, Dr. Wendy Ellis said the bullet that killed Candy traveled left to right, which is inconsistent with what a veterinarian said on the stand Thursday.
The manner of the direction, was it in a front to back downward motion?
I would presume it's front to back because if the entry hole is in the chest and the bullet ended up going into the abdomen, then that's front to back.
There was a veterinarian that testified in this case that the bullet traveled the midline from the left side of the dog to the right side of the dog, but that would be inconsistent with your findings and your surgical procedures with the dog, correct?
From my op report, I don't see necessarily anything that went to the right side of the dog. I didn't have any damage there, but I would say it went from the left side from the chest into the abdomen, and not necessarily out the right side, but definitely around the abdomen, which could include going over to the right side to some degree. I don't know what bullets do once they enter the body, and I heard they ricochet a little bit.
All right, Terri, we now have conflicting reports from the veterinarians regarding how the bullet traveled. How do you think the jury will consider that information?
You know, sometimes the jury ignores expert opinions, especially when they conflict with each other. They sort of cancel the other out. I think the jury's going to be focusing on a couple of things here. First of all, they're going to have to determine whether or not Candy, the dog, was aggressive, and whether or not Dieterle, and this is the important issue, was he afraid for his life? If the answer to both those questions is yes, then I do think Dieterle will be the victor in this case. I think what the jury's also going to look at is did he shoot after the dog after it ran away? That's going to help them determine whether or not he really was in fear of his life.
Yeah. Now, Lisa, you have a well of knowledge on this. Of course, law enforcement works with canines. They come in contact with dogs, and you're a dog mom yourself. So based on your expertise, should Dieterle have done what he did in shooting the dog, or should he have done something different?
I 100% support Dieterle, only because as a police officer responding to scenes, I was bit twice. I did not have any opportunity to respond, to get pepper spray, to get my bat, to even pull my gun. It happened so quickly. And when he explained that he had an opportunity to stop on the ground to try to make the dog stop, it wouldn't stop. He even kicked, he made contact with the dog's head. The dog was still coming at him and aggressing. And he was down to his last resort, which was pulling his gun and protecting himself. One last thing, Brian. 4.5 million Americans are bit every single year. 65% of those dog bites come from the pit bull breed. So you have an intrinsic fear with pit bulls across America. So I think that's going to help him in this case.
Yeah, and that fact will definitely be used in his defense or his argument, and it might further his case. Well, when we come back, Johnny Depp versus Amber Heard. What to expect from... Welcome back. Johnny Depp and Amber Heard's team are headed back to court for a hearing on Friday. Early this month, a Virginia jury largely sided with Johnny Depp in the defamation case seen around the world. Depp sued ex-wife Amber Heard for $50 million, claiming she defamed him as an abuser in a 2018 Washington Post op-ed. Heard fired back with a $100 million countersuit alleging Depp physically and sexually assaulted her. After 6 weeks of testimony, including from both Depp and Heard, jurors awarded Johnny Depp $15 million in damages. Amber Heard was awarded $2 million for statements made by Depp's attorney. Heard was not awarded any punitive damages, though. During Friday's hearing, Judge Penny Axcarati will enter the judgment. Time will also be set aside to discuss other issues. Following the verdict, Heard's attorney indicated she planned to file an appeal in the case. Law and crime legal analyst Catherine Lozardo explains what it would take under Virginia law for that appeal to be filed.
First of all, she has to file a notice of appeal. And in Virginia, she has 30 days from the date that the judgment is entered to file a notice of appeal. It's not 30 days from the date that the jury reached their verdict. And the judgment is the written order that the judge will enter in this case. When the jury reached their verdict, Judge Ascarati said to Bench 2, please go ahead and write the order. And then what Johnny Depp's legal team will do is they'll write that judgment and then show it to Amber Heard's legal team, and there will be a lot of back and forth objections as to how it should be worded, and then it will be given to Judge Ascarati for final approval, and then she will sign it and enter it as the final judgment in the trial court. Only when that is entered, meaning stamp filed in her court, that's when the 30 days start ticking for Amber Heard to file a document called a notice of appeal. Together with the notice of appeal, Amber Heard must also post an appeal bond. The appeal bond is $500 or such sum as the trial court may require, subject to subsection E of that code section. And that subsection E code section, there's a lot of different rules there, but what I wanted to point out is the subsection E just basically says if a party files a motion for the bond to be increased or decreased, then the trial court would have to consider that motion and resolve it or modify the $500.
All right, Lisa, Terry's going to talk to us about this upcoming hearing, but I want to ask you beyond this hearing. With all these interviews and media coverage, do you think this will be the last we hear of Johnny Depp and Amber Heard?
No, hardly, Brian. There's talks right now of Amber writing a book. We have the appeal going forward. She's been cut out of Aquaman. She needs to make money. Johnny's running around on his rock and roll victory tour lap right now. So I would imagine that this continued kind of live action soap opera is far from over.
It's kind of the gift that keeps on giving, but I want to return it. Terry, the trial is over and the verdict has reached. What are our expectations for this upcoming hearing?
What I'm expecting is that the judgment is going to be entered, and as we heard, it is drafted generally by the prevailing party, agreed upon by the losing party. and then it's entered by the judge. And there is really no opportunity to change the jury's decision. But I mean, we could hear at the hearing that there's some discussion about settlement, and that could very well be the case. They could settle, they could come to an agreement. But at that hearing, the judge is absolutely going to enter the verdict that the jury gave. You can only set aside a verdict if there's weight against the evidence and there are reasons to set it aside. So there's going to be the judgment, it's going to be entered, and then there may or may not be a settlement.
All right, may or may not. We'll see how this plays out. Thank you both. And thank you for joining us here on Law and Crime Daily. We'll see you next time as we discuss justice in America.